In this session, we will begin looking at some of the ethical and legal issues surrounding the practice of counseling assessment. Throughout this session, we will look at several different aspects. We will begin our discussion by talking about what is assessment. Having a consistent understanding of what assessment is will help us in ensuring that our actions and behaviors adhere to ethical and legal standards. Assessment goes beyond what many individuals think of as assessment related activities. We'll then look at how assessment is integrated into counseling practice and the different components of what we do as counselors across all settings rely on assessment information. From there, we will talk about some common misconceptions about assessment. The mainstream media has several reports of assessment practices that have gone awry or been conducted in an unethical or invalid manner that has soured many individuals on participating in the assessment practice. This includes both individuals who would take tests either in an educational setting or in a clinical setting, as well as individuals who choose not to use these in their practice. We then will look at some assessment based ethical guidelines so that we could ensure that the way that we are incorporating assessment into our counseling practice follows best practices, codes of conduct for our profession. Finally, we will look at some legal implications. We will talk about laws that have been enacted and litigation that has ensued that have shaped the way that we use assessment practices and interpret the results of assessment data. So let's begin. What is assessment? Assessment is a process. It's a process that integrates test information with information from other sources in an objective manner. Let's break that definition down. Assessment is a process. It is not a singular event. Assessment occurs over time. It occurs at many different levels as well. You'll see that assessment alone is not test data. Tests and the information we gather from a test may be one part of what we assess about an individual, but it is not the whole story. That score does not represent our total understanding of the individual. That test score needs to be integrated with other sources of information. What else is the client telling us? What do we observe? What are we hearing by other individuals who may have a vested interest in this situation or in the life of this individual? How is all of that information coming together to form a rich description of the issue going on with our client? When talking about assessment, you may also hear the terms appraisal or evaluation. These terms are used interchangeably with assessment, but that's not actually the accurate way to describe them. While appraisal and evaluation are similar activities to assessment, there is a significant difference between them. Both appraisal and evaluation have a sense of rating, a subjective rating of an individual. Someone is given a score. Someone is being placed in a group. Someone is being compared to other individuals. Appraisal and evaluation are far more subjective. Assessment is an objective component. The goal of assessment is to gather information, to gather as much information as possible, to be able to truly understand a client and his or her perspective from all angles. Assessment is not necessarily about placing someone or scoring someone. Appraisal and evaluation could be part of the assessment process. So, with that understanding of what assessment is, let's look at how assessment functions in counseling practice. There are some obvious ways that assessment relates to counseling practice. First and foremost, we talk about screening. We gather information about clients to try to understand what's going on, what brings them to counseling, what are some of the present issues. Perhaps the issues that they're sharing are not the problem themselves, but they're a result of an underlying problem. Screening is a way to get that information from the client. With that information, we're able to move into a diagnosis stage. Assessments can be used in helping to diagnose clients based on information shared or observed about their experiences. Once a diagnosis is in place, we could begin working with individuals on identifying some goals and developing treatment plans. These processes also use assessment as well to identify where a client wants to go from here and what are the steps that we would need to take to get from point A to point B and as many steps that follow. And finally, assessment plays a role in progress evaluation. How do we know that counseling is being effective? How do we know when our client is getting better or reaching a new state of functioning or being that is more aligned with the goals that they had? Assessment can help us identify whether we are on the right track or not. But I want you to broaden your perspective and think about how assessment really functions as the quintessential counseling activity. Think of the idea that there is no real therapy without assessment. Assessment is probably the first technique that you use with any client. Imagine a client comes in for the first session with you. What is your immediate reaction to that individual? You are conducting a quick assessment of that individual. What is their affect? What is their cognitive state? How is their dress, their gait, their posture? From the moment we meet an individual, we are assessing that person. We're gathering information that helps us paint a picture and figure out who it is that we are interacting with. Maybe your first interaction is prior to that first session. A client calls to schedule an appointment. That initial phone call, assessment occurs. Why did the individual call? What prompted them to do so at this time? What is the sense of urgency or immediacy that needs to be addressed? Is this someone who I need to refer to a hospital ER or an inpatient screening? So, assessment is always something we're doing in the counseling relationship. If we're always doing it, why is there still a negative perception to assessment? There are several misconceptions that exist amongst professionals and definitely within the general public that sour the name of assessment, that have people view assessment as a dubious activity that has questionable goals and objectives. And so I'd like to talk about some of these misconceptions and how you could address with your clients the truth and the fiction in some of these statements. First is this idea that all assessments are created equal. I would recommend you tell your clients and share with them that this is unequivocally false. All assessments are not created equal. As we've been talking in this class, you see that there are standards in place for the development of assessment measures. The extent to which individuals follow those standards in building assessment will vary. As a consumer of assessment instruments and measures, it is inherent that you study up on the instruments you choose to use. You find out whether they are good instruments or poorly constructed instruments, and determine if they are appropriate for the client with whom you choose to use them. They are not all equal. With just about any construct you can think of, there are multiple measures existing addressing that construct. Not all will be at the same level of quality. As a counselor, it's your responsibility to ensure that you're choosing the best possible instruments. A second misconception is that all assessments measure the same thing. Not necessarily. There may be assessments that measure the same construct, but they do it in different ways. You've learned that throughout the years, intelligence has been viewed in many different ways as a singular construct, a dichotomous construct, all the way up to a multi-tiered approach that looks at intelligence coming from several different sources and activities. With this variety in understanding and definition of terms, there is, of course, a variety of assessment instruments based on those individual definitions. When selecting an item for it to provide you with meaningful data, it should be an instrument that aligns with the approach that you're taking with that individual. A third misconception is that all assessments are impersonal tests. Well, not exactly. The information we gather from assessment tests comes from somewhere. It comes from the individual clients. They are sharing the information. They are providing the responses to the questions or prompts being asked. The level of personal information is dependent on the individual and how much they are willing to share. There is a misconception that assessments take time. They're labor intensive and costly. They can be, but that's not always the case. There are many instruments that are available at no cost. There are also many instruments that are available that require very little advanced training to administer and can be used in a short amount of time. For example, the Patient Health Questionnaire is a quick anxiety and depression screening tool that is available at no cost for clinicians to use. One version is a 9-item scale, but there is an even briefer version, a 4-item PHQ with 2 depression screening questions and 2 anxiety screening questions. It can be administered in a matter of minutes. So assessments don't necessarily need to be long, laborious processes. They can be quick and easy. Typically, this misconception comes from individuals who think of assessment and IQ tests or some of the larger personality inventories. But that is not all assessments. Another misconception is that assessment results are grossly misinterpreted. Again, they can be. That is not necessarily an artifact of the assessment so much as it is of the individual who is using the assessment. Misinterpretation of results is typically more of a user error than it is a problem with the tool or device. If individuals are using assessment and they have not been properly trained to do so, or they are using it in a off-label manner, that's going to create a negative experience for the client who is participating in the assessment. Let your clients know that that is not how the situation always has to be. A really big misconception we hear and see a lot is that assessment is used only to label people. Again, that's just not 100% accurate. Yes, there are some assessments that do, in fact, label people, but that is not the sole purpose. And even those instruments that are designed as diagnostic tools, more goes into the labeling of the individual than that single score. I've often thought that as a counselor, the labeling of individual clients does not necessarily advance the work that we do with them. An individual comes to counseling with a set of experiences. They may be feeling a certain way, thinking a certain way, having difficulties with behaviors. There may be relationship issues. There may be challenges in a whole host of aspects of their life. When they come to counseling and share that information, my ability to provide a label to it and name it does not necessarily change the situation. Whether I tell you you are suffering from schizophrenia or not, you're going to have a lot of the same signs and symptoms. The label itself is not the most prominent feature of assessment. The value in assessment is getting that information that's going to allow you to tailor treatment to that individual. Assessments invade personal privacy. Assessments gather information that individuals are willing to share. As we talk about in our ethical practices, individuals partaking in assessment must be provided with informed consent, and their participation is voluntary. If a client does not want to share information, they're not required to, unless there is a specific court ruling mandating such. Assessments only invade personal privacy as much as individuals are willing to give access to. Assessments are unable to capture individuality. Yes, it's true that it would be very difficult to create a singular instrument or measure that addressed the unique situation of everyone who took that instrument. There is some commonality at play here. Scores of instruments are based on norm groups and similar type individuals. But there is some individuality. The use of assessment should take into consideration context. And it's that context combined with the score reported that sees the uniqueness in the individual client. Another misconception is that assessment gives inconsistent results. This is true, and that's not necessarily a bad thing. There could be situations where inconsistent results are what you want. If you're working with a depressed client and you're using a Beck Depression Inventory with that individual, you would hope to see inconsistent results. Your client would hope to see inconsistent results. We would like to see your score change session after session or administration after administration. That's a sign that therapy is working. Symptoms experienced or severity of those symptoms is decreasing. And finally, the idea that assessments are unfair and they bias certain individuals. Unfortunately, that's true in some cases, but not all of them. In fact, we will talk about a number of cases in which assessment was biasing individuals. That does not mean that's the case for all assessment. And so, again, this is where it's important to share with your client in that informed consent what the purpose of testing is and why this is an intervention you're choosing to use at this moment. So, what's ethical and what's legal? Let's look at the definition of these two terms. Ethics refers to the rules or standards governing the conduct of members of a profession. They reference what a person should or should not do according to principles and norms of conduct. So we could break that definition down into its critical components. First, notice that ethics are standards or rules that govern the conduct of members of a profession. As counselors, as helping professionals, we have a code of ethics for professional counselors. In fact, we have several. We, as counselors, adhere to our professional counseling code of ethics. Other professions, doctors, lawyers, architects, contractors, all have a code of ethics. Just because codes exist doesn't mean everybody has to follow them. We follow the ones that apply to our profession. These codes are designed by the members of the profession as well. So there is a inherent understanding of the process and the experience and what it's like to be a counselor sitting across from a client. These ethical codes describe norms of conduct. The ethical codes are based on the principle what would be reasonable to expect by a professional counselor in this situation. Behaviors that deviate from that are those that may have questionable ethics or outright be unethical. The other term we talk about are laws. Laws are defined as the body of rules governing the affairs of persons with a community, state, or country. So there is this proximal component to laws. Laws are created by governing parties. Those individuals who are making the law are not necessarily individuals who are part of the guild or the profession. They are policing. Not everyone who is voting on a law has been a counselor or has been in counseling or knows counseling interns or supervisors. Laws are more proximal. They apply to the local area in which they were developed. The laws of my community may be different than the laws of someone else's community. What we do in Texas may look vastly different than what they do in Illinois or Oregon. Similarly, laws in other countries may be different than laws we have here in the United States. At both these levels, ethics and laws apply to not only counseling practice, but assessment in particular. So there are several different sources of ethical information for professional counselors. Depending on the organizations to which you belong and the training programs that you are participating in, as well as the different licensing and credentialing boards to whom you hope to one day receive your license or certification, different ethical standards apply to you as an individual. So, in this section, we will focus on the ACA Code of Ethics, but there are other sources of ethical information that are important for you to recognize as someone who may be involved in assessment practices. A second document is the Rust Statement. The Rust Statement talks about the rights of users of standardized tests. So, Individuals, researchers, practitioners who will one day be using standardized tests in their practice or work with individuals have some ethical responsibilities. The Rust Statement was developed by the ACA Division, Association for Assessment in Research and Counseling, AARC, and several of its leadership back in the early 2000s. The Code of Fair Testing Practices in Education was developed by the Joint Committee of Testing Professionals. This committee draws on individuals from educational fields, psychology, and counseling. It describes the way assessments are used in school-based settings as a classroom experience and extracurricular experience too. The Rights and Responsibilities of Test Takers is another document published by the Joint Committee of Testing Professionals. Much like the Rust Statement, the Rights and Responsibilities talks about what is required of individuals in the assessment process. The big difference, however, is this one focused on test takers. So the clients, the students who will be participating in the testing process. This document talks about their responsibilities to be an informed test taker, to understand what is being asked of them, what information will be gathered, how that information will be used. And then finally, we look at CACREP accreditation standards. So the CACREP standards do not accredit programs specifically. They do not accredit faculty specifically. They do not even relate to students. What they relate to are curriculum. Are students being provided with a robust curriculum that meets specific learning objectives? Included in those learning objectives are curricular experiences related to assessment. So let's talk about the ACA Code of Ethics. I focus on this one primarily for a number of reasons. First, it is the code of ethics that the Department of Counseling and Educational Psychology has endorsed as being a requirement for all of our students at the master's and doctoral level to adhere to as part of their admission and continued good standing in the program. Second, for those of you that are hoping to achieve licensure one day, the Code of Ethics is used by state licensing boards for individuals who are seeking credentialing. And third, hopefully, as you're building your professional identity, you are seeing the value in being a member of different counseling organizations, and you're joining an organization, either ACA or one of its divisions, that also adhere to this code of ethics. Now, the codes talk about all aspects of counseling processes and interaction with clients. But I would like to draw your attention specifically to Section E. Section E is the evaluation, assessment, and interpretation section. There are 12 different subsections in Section E. You could read about these in your copy of the ACA Code of Ethics. I want to just highlight for you what is addressed in these sections. So you will see not only is there a general overview on what assessment is and how it can be a useful part of the counseling process, but also a strong focus on client welfare. Being able to act in a professional way that does not jeopardize or harm individual clients in any way. That harm could be intentional or unintentional, and we'll talk about the difference between the two in a few moments. Additionally, we look at ethics surrounding the use and interpretation of assessment instruments, making sure that we're choosing instruments that are appropriate for what we're trying to accomplish and that we are trained to use. There are ethical standards related to the informed consent process, getting clients on board with what assessment is going to look like and what they will be asked to do. There's also discussion of releasing the information to qualified personnel. Once we assess clients, who has access to the information that we collect? How is that information used? Or how is it safeguarded and protected? We look at information related to diagnosing mental disorders. This is a high stakes area with several implications, positive and negative, of labeling and identifying individuals with mental disorders. So, extreme caution and ethical care is needed in this area. Again, looking at the selection of instruments, ensuring that we're using the highest quality instruments with our clients, paying attention to the conditions at which we are administering assessment, making sure that we have created an environment and an atmosphere that is conducive to clients performing at their best. There's ethical standards that talk about using assessment practices with diverse and multicultural groups. We'll talk about several examples in which that was not always the case and the aftermath of those decisions. Of course, you're going to have information related to scores and how those scores are reported or safeguarded or held so that clients' confidential information is not shared. We'll have standards relating to the maintenance and security of the instrument to maintain the integrity of the process, what to do when we have outdated assessment instruments and we are trying to capture a more nuanced or local perspective of these individuals and their issues for which they present for treatment. We look at the construction of instruments. So we've been talking about in this class, there are several steps in the process to constructing instruments. The ethics that surround that ensure that we come up with an instrument that is useful for a wide variety of clients. And then finally, forensic evaluations. More and more, the legal system is turning to psychology, counseling, social work, the mental health fields to contribute information that can be useful in the decisions that need to be made by these courts. So, forensic evaluations are having a large part in several different types of cases. Because, again, of the high stakes nature of these decisions, there are a growing number of ethical considerations that need to be taken into account to ensure that the process is beneficial for all participants. This section is a new section that was not in the previous ACA Code of Ethics and represents an understanding of where the field is going and how a greater merger with technology seems to be common practice in the counseling field. So I want to start our focused look at the selection of assessments. When selecting assessments, there are a number of things that you will want to ensure or establish are in place before using. One is the validity of the assessment procedures. In doing so, you want to make sure that the assessment that you are choosing to use is valid for the purpose in which you intend to use it. If you were trying to identify if an individual has any suicidal ideations, you would want to choose a measure that was designed to assess that component. If you are working with a couple on communication skills, then you would want to choose an instrument that was designed to assess communication patterns between couples. You want to make sure that the assessment you're using is appropriate for the client or the sample demographics in which you will be working. If an assessment was designed for children and you're working with adults, it may not be the best choice. Make sure that what you're using can be applied to the population from whom you're drawing your sample. And finally, we select assessments that we are properly trained to administer. Our decisions over which tests to use should not be driven by who has the best amount of swag that they could present, which is the most popular test at a time, what are all of my colleagues using. Your decision should be based on what you are able to use based on your skill or training level, and what is best in terms of meeting client needs at this time. As a user of tests, there are certain components that you need to consider to see if you are qualified to use that test. The first is the purpose of testing. You should have a clear purpose for your testing established before you even begin engaging in the process. Because the purpose of testing directs how the results will be used, qualifications beyond general testing competencies may be needed to interpret and apply the data. Second, you need to consider characteristics of tests. Understanding the strengths and limitations of each instrument is a requirement. As a user of tests, it is incumbent on you to be knowledgeable about various assessments in your field and being able to weigh the pros and cons of each and make a rational decision for when to use which test with which client. In terms of settings and conditions of test use, assessment of the quality and relevance of a test user's knowledge and skill to the situation is needed before deciding to test or participate in a program. Again, what are you eligible to be using as a test user based on your background? And then finally, what is the role of you as the test selector or administrator, scorer, or interpreter? What types of qualifications do you need to participate in these various roles? Well, most of the testing companies assist in identifying qualifications needed for individuals to use their tests. While the terminology may change slightly, all of the major testing companies work on a process whereby you, as an individual prospective test user, will need to first be credentialed in their system. That credentialing process results in you, as a test user, receiving a qualification level. And the levels are A, B, or C. These levels correspond to the instruments that you are able to purchase and use from that testing company. A level A assessment requires no special qualifications to purchase or use. A layperson could use these instruments. All they would need to do is have the ability to read the instruction manuals and apply accordingly. This is the base level of assessment qualification. Above level A is the level B qualification. Level B qualification requires individuals to have a master's degree and formal training in the ethical administration, scoring, and interpretation of clinical assessments. So, individuals in counseling or counseling related fields can use level B instruments if, in their master's entry level program, they had a course in instrument use, psychological testing, assessment, appraisal, psychometrics, any of these types of courses that cover this content would suffice. At the highest level, the level C, individuals need an advanced degree. So, your doctorate degree, as well as advanced training in that instrument. Some of the level C instruments require whole courses be taken in those instruments. Many of the intelligence tests now require coursework in those tests to be qualified to use them. In addition to the doctorate and the advanced training, a practice license and membership in a professional organization, for us, ACA, is required. At this level, the level C, individuals are qualified to purchase any assessment and use that assessment with clients. Just because an individual qualifies at a certain level doesn't then end their responsibility. Throughout the process, that individual needs to use the measure purchased and selected in a way that is consistent with its initial instructions for administration, scoring, and utility. So I mentioned earlier with those different documents, there are responsibilities that you, the counselor, have in the process of using assessment, and there are responsibilities that the client has as well. On the counselor's end, there are responsibilities for selecting appropriate instruments, safeguarding client welfare throughout the process, maintaining the integrity of the assessment process, and making sure that the scales do not get out into the public or there is any compromise of the interpretation process for an individual. Counselors are responsible for educating their clients and for performing comprehensive evaluation of all the assessment results. Before sharing the results with the client, counselors should go through and make sure that there were no errors in scoring or interpretation of results. Clients should be educated as well. As part of our practice as the counselor, we should be educating clients on the tests. Clients should then be able to articulate the purpose of the test. Why are they taking this test? What was the decision points that went into deciding on this version as opposed to a different test that may accomplish the same purpose? What are the different testing conditions available? If I, as a client, am somebody who has a disability or may need accommodations, what's available to me as an option? How would I go about getting those accommodations if needed? Clients should ask about the constructs that are being assessed. What will you be learning about me through this instrument? How are those constructs defined? Let the client figure out if it's consistent with their understanding of the construct. It's hard to assess someone and tell them that they score at this level and it means this if that's not their understanding. We should share with the clients the administrative procedures and scoring methods. Again, are we using a computer scoring, hand scoring? Is it self-scored? What does that look like? And then what is done with that score? Is it a total score? Are there different section scores? And finally, educate clients on sample questions. What kinds of questions will you be asked? Talk about the type as well as the format. If you have access, maybe you share a sample question with the individual so they get a sense of what the test looks like and they know what it is they're going to be responding to before they take the test so they're not caught off guard. For both parties, counselor and client, knowing about what the scores are used for. Is it going to be a placement exam? Was there unusual testing conditions? The room was too hot, too cold, too crowded. The computer wouldn't turn on for the first 20 minutes. What behavioral observations were there? I could tell that the client was getting agitated while taking this instrument. The client broke 3 pencils in half while taking this instrument. Is there anything to the client's response style? Or is it important to note when the exam was? Again, we've talked about differences between assessing, collecting information from people at 8 in the morning versus 8 in the evening. or perhaps in the midday, either right before or right after a break. Additional responsibilities of clients is to know their responsibilities, to participate in assessments of high professional standard. If they don't feel comfortable, don't engage in the practice. Ask questions. Clients are equal participants in this process, so ask questions. Clients are responsible for listening to the directions or reading the directions carefully and knowing the limitations of what they're being tested on, the parameters of confidentiality that surround their scores, and what's going to be done with those scores. So, a lot goes into the assessment practice, and a lot is expected of practitioners as well as clients to ensure that the process runs smoothly and is a positive experience by all that benefits the therapeutic process. So, we've talked about the ethical components. I now want to turn to the legal aspect of assessment practice. When we talk about the legal issues, there are two sides to this: legislation and litigation. Legislation refers to the act of making or enacting laws. Collectively, statutory laws are known as legislation. On the flip side is litigation. Litigation refers to legal proceedings that are enacted to resolve a dispute. Typically, an impartial third party, usually a court, is brought in to settle disputes. So let's look at some legislation. So, throughout the years, there has been some landmark legislation that governs many different aspects of societal life, but has an impact on assessment practices as well. The first is the Family Educational Rights and Privacy Act, FERPA. In 1974, Congress enacted FERPA legislation. FERPA protects the privacy of students and their parents. This act is designed to ensure that students and the parents of these students are able to obtain access to a student's educational records, as well as challenge the content or release of these records to third parties. A couple things to consider with FERPA. According to FERPA, a student is an individual who is enrolled in and actually attends an educational institution. Both components need to be in place. Attendance includes, but is not limited to, in person or correspondence attendance. Individuals who audit classes or who are accepted to an institution but never attend classes are not considered students under FERPA regulation. FERPA prohibits the disclosure of a student's protected information to a third party. This includes disclosures that are made by hand, verbally, by email, or any other electronic transmission. Third parties can include any other individuals or organizations other than the student and the student's parents. Where FERPA applies to assessment practice is the implication that No student shall be required, without parental permission, to submit to psychological examination, testing, or treatment that may reveal information concerning mental and/or psychological problems of a sensitive nature. So individuals have the right to determine whether or not they want to partake in these activities. If they feel that it is going to be a threat or a challenge to them or potentially release sensitive information about them, and they don't feel comfortable participating, they cannot be mandated to do so. A somewhat similar law is the Health Information Portability and Accountability Act, HIPAA. HIPAA was enacted in 1996, and it provides the ability to transfer and continue health insurance coverage for millions of American workers and their families. In addition to accessing health records, the HIPAA Act provided a clear description of protected health information, PHI. Under HIPAA, PHI is considered to be any identifiable health information that can be used or is maintained, stored, or transmitted by HIPAA covered entities. It covers past, present, and future information. HIPAA applies to assessment results as well. Assessment results fall under the category of a individual's personal health information. So as practitioners, if we are collecting assessment results, we need client permission to share that information. Some other landmark legislative issues. Public Law 94-142. This law in 1975 provided fair and equitable access to education for everyone. Educators are responsible for identifying and providing special education in the least restrictive method to individuals with exceptionalities. Public Law 99-457, a decade later, extended PL 94142 to all children above the age of 3, widening the scope to include preschool as well. The Americans with Disabilities Act of 1990 stipulated that reasonable and appropriate testing accommodations needed to be provided. This includes extended times, alternate locations or formats. In addition, testing materials and procedures had to be essential to the job and not discriminate against persons with disabilities when used as part of a selection process. The Individuals with Disabilities Act of 1990 and then the reenactment in 1997 stipulated that multiple testing methods must be employed when attempting to diagnose disabilities, and that any assessment of individuals needed to include cognitive as well as behavioral factors in the assessment. In 1991, the revision of the Civil Rights Act, it codified testing principles and abolished the use of separate norming groups for different minority groups. The law now made it unlawful to use different cut scores across racial groups. And finally, in 2011, No Child Left Behind. The No Child Left Behind law established school accountability standards. Periodic assessment was needed of schools to gauge the progress of the school in improving the academic achievement of its students and the learning environment it was providing. Many of our advancements in assessment and the way that assessment data is used in making high stakes decisions has been impacted by important legal precedents. A number of court cases throughout the years have helped to identify what is best practices in using assessment data. The first case I want to look at is Hobson versus Hansen in 1967. Julius Hobson, a civil rights activist, filed a class action lawsuit in federal court against the Board of Education of the District of Columbia and its superintendent at the time, Carl Hansen. In the suit, Hobson and his lawyers argued that low-income Black students were denied equal educational opportunity as a result of discriminatory practices in the district. Specifically, they took umbrage with the fact that the district used a policy of grouping students based on ability into tracks. Once individual students were assigned to these tracks, there was virtually no opportunity for them to switch tracks. Based on the track they were placed in, students received a different quality education and were geared towards or directed to opportunities at differing career paths. Those individuals in the lowest track received lesser education and were geared more towards lower paying blue collar jobs, while honors students were placed in the higher track and they took college prep courses. The lawsuit argued that low income and Black students were disproportionately represented in the lower tracks. This was one of the first cases to challenge the discriminatory practice of using standardized aptitude tests for ability tracking and the segregation that it fostered. The court ruled in favor of Hobson and found that the practice was discriminatory. However, they ruled that it was discriminatory in effect, in other words, its outcome, but not its intent. A second case in 1971 is Griggs versus Duke Power Company. Willie Griggs filed a class action lawsuit on behalf of several African American employees who worked for Duke Power Company. Duke Power Company is a multi-state energy company in the Southeast. In the 60s and 70s, Duke Power had an inside transfer policy whereby individuals who worked with the company could test into higher paying jobs. To do so, individuals had to achieve a minimum score on 2 separate aptitude tests and document having a high school education. This case made it all the way to the Supreme Court, and the question posed before the court was whether or not Duke Power Company's transfer policy requiring high school education and aptitude test scores violated Title VII of the Civil Rights Act. In its unanimous ruling, the court said, yes, this did violate the Civil Rights Act, since neither measure, having a high school diploma or passing these aptitude tests, was directed or intended to measure the employee's ability to learn or perform a particular job. In other words, the criteria they were using was not related to the skills one would have to demonstrate to be successful in upper level positions with the company. The third case, Larry P. Riles, in 1974, this was actually a multi-year case. In the early 1970s, the parents of 6 African American elementary school children in San Francisco filed suit against the California Department of Education. Their claim was that African American children in California were being placed, or in the future might be placed, in special education classes at a higher rate than students from other groups. The school system was trying to assist children with learning disabilities, and so they created a special track for students who had mental disabilities and learning disabilities. They called their classes EMR classes, or Educable Mentally Retarded Classes. They were designed for children found to be incapable of learning in regular classes, who were preventing students from developing the skills necessary to return to a regular school environment. To classify children as being admitted to these courses or not, the California School Board was using IQ tests. In the lawsuit, the families contended that the process was biased against African American children, leading to increased socioeconomic and educational disparity. The case went through several appeals, and it was not until 1986 that a verdict was reached. In the court's ruling, alternate means of assessment were needed. Again, the court did not rule that there was intended discrimination, only discriminatory outcomes from the practice. So the school board was no longer allowed to just use IQ scores to place students in school. Multiple measures are needed for making these high stakes decisions. And we talked about this earlier when it comes to educational placement, that a variety of sources of data are needed. Deborah P. versus Turlington took place in Florida. In 1978, the Florida legislature passed a law that one of the conditions of receiving a high school diploma was that individuals had to pass a state competency examination. Initial data showed that Black students had a disproportionate failing rate on the test. Federal court officials found that the content of the test was valid and its use for remediation purposes was legal. However, to avoid perpetuating past discrimination against Black students, the court placed a sanction that did not put this new rule into effect until 1982 or 1983. In essence, during the 60s and 70s, there was still segregation in schools in terms of access to materials. Low-income schools where many of the Black students attended did not have access to the educational materials and the curriculum that was being tested on this competency examination. The court's ruling put off the requirement until 1983, when all students who would be graduating that year would have come through a full educational curriculum from grade 1 on, in which they were in racially integrated schools. This was another case that went through several appeals. Ultimately, the court reasoned that the test was instructionally valid and there was no causal link between the performance of Black students and the effects of past discrimination. As it stood, individuals had to pass the exam to get their diploma. If they did not pass the exam, they could apply to receive a certificate of completion, which they could exchange for a diploma if they were able to pass the test on later attempts. Students were given 5 opportunities to pass the test prior to graduation, and remediation attempts were put in place to help them. The next case, Sharif versus the New York State Department of Education. The New York State Department of Education was offering scholarships. They had 2 scholarships that were merit-based. They had a Regents Scholarship and an Empire State Scholarship. At the time that these scholarships were enacted, individuals who received them would have their college paid for if they went to a New York State university. The criteria for receiving one of these scholarships was SAT scores. That was the sole criteria used. The plaintiffs in this case argued that the SAT score disenfranchised female high school students who, as a group, consistently score on average 60 points lower than their male counterparts. This was despite the fact that many female high school seniors, as a group, were performing as well or better in their high school courses as all other students. The defendants' reliance on using the SAT as the single criterion for awarding the state merit scholarships resulted in a consistent pattern. Females received only 43 and 28% of the Regents and Empire State scholarships, respectively, although they made up nearly 55% of the applicant pool. The courts ruled in their favor, saying that the school district could not use the SAT in this manner. Specifically, they cited the purpose of the SAT as an aptitude test which measures potential for future success and not past achievement, which is what the scholarships were recognizing. In Price Waterhouse versus Hopkins, the plaintiff, Ann Hopkins, was denied a partnership at the Price Waterhouse law firm because her employers believed she was insufficiently stereotypically feminine. To improve her chances of making partner, she was told in her performance review that if she would walk more femininely, talk more femininely, dress more femininely, wear makeup, and have her hair styled and wear jewelry, she would have a better chance of becoming a partner. She sued the firm and she won a favorable decision that the firm was discriminating against her on the basis of sex under Title VII of the Civil Rights Act of 1964. In their decision, the Supreme Court clarified that discrimination because of one's sex assigned at birth was not the full extent of the law. Also prohibited was discrimination based on gender stereotyping. They ruled that it was impermissible to treat employees differently based on their sex, and also impermissible to treat employees differently because they are not the right kind of man, woman, or non binary person according to their employer. Soroka versus the Dayton Hudson Company. Dayton Hudson Company is the parent company that owns the Target department stores. In the 90s, individuals who were seeking employment as security guards at Target had to pass a psychological screening profiler as a condition of their hiring. The screening profile that they used asked a number of personal questions related to an individual's beliefs and attitudes towards religion and sexuality. The group of security guards who collectively brought this suit against the company argued that the information being requested was of a personal nature that could be used in a negative aspect against them. That the information provided on this screening in no way related to their ability to perform their job as security guards. The courts ruled in favor of the plaintiffs, citing this fact that the instrument and its intended purpose did not align with the placement decisions being made based on their scores. In Jaffe versus Redmond, this is the case in which a police officer was called to the scene of a crime. Upon arriving at the scene, an individual was running out of the house. The officer tried to get the person to stop, thought the individual had something in their hand, and to prevent any other danger, shot and killed the individual. The family brought suit against the officer, alleging constitutional violations and damages for wrongful death. After the shooting, the officer sought counseling from a licensed clinical social worker. The plaintiffs in the case tried to get information regarding the contents of those counseling sessions. The counselor refused, citing psychotherapist patient privilege. The courts ruled in favor of the defendants, saying that the psychotherapist patient privilege did apply and that information gained at that intake screening by the social worker could not be used as evidence or brought up in the wrongful death suit. This court case reaffirmed the protection of information gained in a clinical setting. Atkins versus Virginia. Daryl Atkins was convicted of abduction, armed robbery, and capital murder. During the penalty phase of his trial, the defense called one witness, a forensic psychologist, who testified that Atkins was mildly mentally disabled. The jury sentenced Atkins to death, but the Supreme Court ordered a second sentencing because of logistical issues with the court using the wrong verdict form. During resentencing, the same psychologist testified, but this time the state rebutted his intelligence. The Supreme Court heard the case and ruled in favor of Atkins, stating that cruel and unusual punishment to sentence a person with intellectual challenges to death. Another example of the importance of having multiple sources of information when making high-stakes decisions. And finally, Fisher versus the University of Texas at Austin, a recent case. In 1997, the Texas legislature enacted a law whereby the University of Texas would admit all high school seniors who ranked in the top 10% of their high school classes. After a review of their admissions, UT officials found that there were differences between racial and ethnic makeup of the university's undergraduate population and the state population. To address this situation and increase the diversity of the university, UT modified its race-neutral admissions policies. After admitting all in-state students who graduated in the top 10% of their high school classes, for the remainder of the in-state freshman class, with whatever seats were still available, the university would consider race as a factor in the admission. A student, Fisher, filed suit saying that as a white student, she was not admitted and that she was being discriminated against. The courts actually ruled in favor of the university and argued that they could use race as a factor in admission, but not the sole factor. So this is just a selection of cases that involve the use of assessment data to make decisions about an individual in academic settings, in legal cases, and employment settings. In all of these cases, how information is used, who it was shared with, and how it may potentially or unintentionally bias certain groups were assessed. All of these highlight the importance of ensuring that the assessment practices we use are of the highest quality, appropriate for the individual, and those in which we are well tested. So how do we ensure fairness in the assessment process? A couple of ways to do that. First, remember that our primary goal as counselors is to promote the welfare of clients. Information that we collect, assessments that we administer, are all designed to help our clients. We should remember that that is the ultimate goal. The information should not be the end goal. Rather, it should be a tool that we use to help individuals. As counselors, we need to engage in professional development opportunities to keep updated with new methods and new uses. When our skills and knowledge fall behind, we're not able to provide top quality care to our clients. We should continually monitor and challenge our personal belief systems and attitudes with regards to diversity. Are we making decisions that may disenfranchise certain populations with whom we work? Are the instruments and the tools we use appropriate and normed for the groups with whom we're using them? In doing so, we're able to better demonstrate competence and employ practices that are culturally sensitive in our counseling work, making sure we're being responsive to those individuals. And finally, being aware of bias in assessment. Bias comes from several different sources. Things to consider: the content bias. Is the material on the assessment we have selected more familiar to one group than another? May we be disenfranchising one group right from the onset? Is there internal structure bias, where scores are more reliable for one group than another? If so, it calls into question the decisions we make based on the information we collect. And thirdly, we look for predictive bias. This occurs when an instrument systematically either overpredicts or underpredicts a group's performance. All of these attest to the fact that it is important to have multiple sources of information when assessing individuals. Relying on a singular score from a specific scale, measure, or instrument may leave out valuable information that would help you make a more informed decision about an individual. So, as you engage in assessment practices as counselors or train a generation of counselors in how to use assessment as future counselor educators, be aware of the importance our decisions have and the impact they have on the lives of others.